Hey guys, and welcome to today's video. Today, we have a sovereign citizen who was fired from her job as a correctional officer for trying to bring in drugs into the jail that she worked at. Now, this isn't your typical got fired from your job for bad performance issue. Trying to smuggle drugs into a correctional facility is a major crime, and for whatever reason, she's decided to represent herself on the day that she has to pay the price for that. Now, I'm not going to post the full trial as it was over 5 hours long. What I'm going to show you today is a small clip from the middle and the explosive conclusion. Colin and I will be watching most of the trial on his channel on Monday night, so I highly suggest you go sub to his channel if you don't want to miss that. Speaking of Colin, have I told you guys that last year I was in a fantasy football league with Colin and a few other content creators, and I beat the shit out of every last one of them to win the championship? Fantasy sports is one of my hobbies outside of YouTube. And recently I've been using today's sponsor, Prize Picks, to turn my hobby into some cash. Prize Picks is a daily sports app that covers all sorts of sports from baseball, basketball, and football to darts, esports, and cricket. Or how they like to say it in France, cricket. And with basketball playoffs right around the corner, Prize Picks makes it easy to turn your sports knowledge into some cold hard cash. You simply choose more or less when it comes to a player's final stat line, and if you guess correctly, you win. And you can mix and match sports. So let's say, for instance, I want to play Luka Doncic and I want to take the more on his points. I just simply select his name, scroll over to what I think he's going to play, because I think he's going to do way more than 29 points, so I'm going to select 38.5, and then I'm going to select the more. Then we head over to the baseball side, and I'm going to select Josh Naylor to have more than a 6.5 hitting score. At the bottom, it tells me what my final payout would be, and all I have to do is hit finalize lineup and then submit. PrizePicks also gives you stats on previous games to help you make more informed decisions about your lineups. You know, looking down at this, I see another great opportunity to take Nikola Jokic's 50.5 combined points, rebounds, and assists and taking the more on that, and then pairing it and taking the more on Luka Doncic's 3.5 three-pointers made. PrizePicks is simply a great app that brings together the enjoyment of watching sports with the excitement of winning money. So download the app today and use code Skeptic to get $50 instantly after you play your first $5 lineup. That's code Skeptic to get $50 instantly after you play your first $5 lineup. PrizePicks, run your game. Now to start, we're going to jump into the middle of the trial after two witnesses have already testified against the Sovtard, because she believes that one of the upcoming witnesses is part of some grand conspiracy to force her to bring drugs into the jail. So let's begin.
All right, and let me move on now. I want to perfect the record just in case it wasn't clear during the bench conference. There was an objection made. Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really.
Yeah,
I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a picture, a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey, Captain Winfrey?
Captain Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
Okay, so yes,
Lieutenant Grady.
it's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger, I was in danger, and there was a instance that happened in the car. But I got
I'll be
familiar
honest with you.
from that
I'm still
from
not
that
sure what
situation.
she's
I
talking
found out
about
a couple days
because
after
she
the baby
consistently
shower.
starts to form an idea but never finishes it. So far, I've heard that she was assaulted, that she has chlamydia, that there was a baby shower thrown for her, that she walks like a model, and she was threatened with a Polaroid of her son to commit the crimes that she claims she didn't do. I mean, what in the actual fuck is going on here?
Okay, I'm just trying to break this down. Is it your claim that someone from an inmate in the jail or another employee there
That may have
did this
possibly
sexual assault?
that may have been the one to do. I don't know who the person was.
Where
But
where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet
Let me rephrase. Did this incident happen inside the jail or outside of the jail?
outside the jail, but I was working with Fulton County at the time.
All right. So the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Do you have any reason to believe that he did?
Because if he's aware of the baby shower,
Oh, no, that's not my question. Not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower, because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from. Anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail, because they have a picture of my son. They have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay. I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next.
Yes.
Okay. Well, glad we're talking about it now then. All right. Well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think
Right.
the state's objection to facts, not in evidence, is one that could very well come again.
Okay.
And we'll see where that takes us.
Okay, so the judge is going to allow her to ask these very obscure questions. There's only one problem. She doesn't even know who she's talking about.
Hey, how you doing? Just stating on the record, I do have the wrong person. This is not the person that was, wrong name.
All right, just for the record, Mr. Miller, can you summarize what exhibits are on the stack that are going to the jury?
What will be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the caduceus report. And State's Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, Your Honor.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a
Yeah.
copy of the oath?
If you've already got it, yeah, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office, I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else, I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure, I'm not too quite sure if that matches what I actually signed when I started working with Fulton County. And that's all.
Oh yes, the classic not my signature defense. Unfortunately for her, she also admitted to signing an oath of office in that very same sentence. So we'll see how that works out for her.
All right. Well, if that's all, the objection I'm hearing is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted and there was no objection. So those being the only grounds, then your objection is overruled and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, State's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm gonna do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
1:50.
All right, so this is the point where they break and come back for closing arguments. Now, I want you to remember what the judge just said, that they'd be taking a 15-minute recess and be coming back at 1:50. Now, I want you to remember this because when they reconvene, one party is there and one party is not.
All right, we are now back on the record. The time is just before 2:05. It's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind, but otherwise all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments? Then let's bring back the jury.
So at this point, they bring in the jury, and the prosecution alone delivers closing arguments. Now, the defendant does return, but only after the jury left for deliberations.
Is this for me? Judge, is this hers?
I don't know what that
This is
is.
jury charges.
Yeah, that's hers.
Yeah.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag if that's possible.
Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you could just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Prior Street, which is south of us, and made a left at Mitchell and Prior, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes, Your Honor.
And that's several blocks away from the courthouse. All right. Ms. Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Ms. Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting reports that you all are calling my mother and my father instead of the phone number I gave.
Well, first off, it's not the court's responsibility to make sure that you return back to court on time. He clearly said return at 1:50, and you didn't come back until 4 p.m. At this point, the court loses all confidence in the defendant's ability to complete the trial without absconding. So a bench warrant was issued, and she was remanded into custody for the rest of the trial.
All right. Well, I think we've put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked your bond, I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would
Because
be
you can't deny
no.
that injustice.
And that
Okay.
I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum, are they referencing a minimum sentence? Or an amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no, and then just reread the intent charge, and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the record, being that this is equity jurisdiction.
And it was at this point that her sovereign citizen side really started to shine like the burnt out light bulb that it is. Because while it may be news to some and not others, the courts have criminal, civil, and equitable jurisdictions. Criminal jurisdiction to hand out criminal punishments like fines and jail time. Civil jurisdiction to hand out civil punishments like monetary damages. And equity jurisdiction to hand out equitable or non-monetary punishments like getting an injunction to stop a builder from building on a particular property. There, now you've learned something today.
Anything else?
No, I need an answer, because being that I told you that your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice, I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done?
No, I'm not. Are you recontracting the
All right.
trust?
You remember what I told you at the outset of this trial, which is that if we started getting into
You
it, you
haven't
started
answered the
interrupting
question.
me. All right, Ms. Young, I'm going to find you in contempt of court.
Are you
And
in
I'm
contempt
immediately
of
imposing a
justice,
20-day
though?
sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm
So
finding you
trying
in
to see how,
contempt a
as a
second
judge,
time, Miss Young. That is an additional 20-day sentence I'm imposing.
you can do as you please, because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you
please
cannot
escort Miss Young
refuse.
from the courtroom.
Come
I
on,
find her
yeah.
as
You'll be hearing my
disrupting our
fee schedule. Let me
proceedings.
put this up.
I got that. I'll bring
And
that
you know
back.
you're in contempt of justice. It's okay. You'll be hearing my fee schedule.
And how exactly is the judge supposed to hear from your fee schedule when you won't shut your mouth long enough for your fee schedule to speak? Now, after receiving her back-to-back contempt of courts, the jury was able to reach a verdict and they're prepared to deliver it.
All right. We're back on the record. I've been informed by Lieutenant Lattimore that the jury has reached a verdict, and Miss Young is now present back in court. And Miss Young, I will remind and direct you once again that there are not to be any verbal outbursts, and I'll allow you to perfect the record at the appropriate time, but that is only going to be when I call on you. So with that, we can bring in the jury.
All judges are present, Your Honor.
Thank you, Lieutenant Lattimore. Please be seated, everyone. Members of the jury, I've been informed that y'all have been able to reach a verdict. And if that is the case, it appears that juror number 8 is our foreperson. All right, if you could hand that verdict form to the lieutenant so that I can take a look and make sure it's been completed. All right, and you can hand that back to our foreperson. And sir, if you could now publish the verdict in open court by reading it, you can remain seated and read it into the record.
Count one, possession of a Schedule I controlled substance with the intent to distribute, you find the defendant guilty. As to count two, possession of a Schedule I controlled substance, we find the defendant guilty. As to count three, crossing guard lines, we the jury find the defendant guilty. As to count four, possession of a Schedule II controlled substance with intent to distribute, we the jury find the defendant guilty. As to count five, possession of a Schedule II controlled substance, we the jury find the defendant guilty. As to count six, crossing guard lines, we the jury find the defendant guilty. As to count seven, possession of a Schedule IV controlled substance with intent to distribute, we the jury find the defendant guilty. As to count eight, possession of a Schedule IV controlled substance, we the jury find the defendant guilty. As to count nine, crossing guard lines, we the jury find the defendant guilty. As to count 10, violation of oath by a public officer, we the jury find the defendant guilty.
And that has been signed, filled in, and dated by you.
Right.
All right, if you could hand that verdict form back to the deputy so that the state may review it as well as the defendant.
Oh, I've seen this.
All right, starting with the state, is there any objection to the form of the verdict, and is there any reason this jury cannot be excused?
No objection, Your Honor.
All right, and over to Ms. Young. Any objection to the form of the verdict, and is there any reason this jury cannot be excused?
There's an object.
All
You're
right.
still in contempt of justice, but that's it.
He may be in contempt of justice, but at least he's not a freshly convicted felon with a love for the smell of computer duster. One who's about to do a lot of time for the crime she's just been convicted of.
All right, we're back on the record for sentencing. I'll begin with the state to present any evidence in aggravation. And let's also start with your recommendation as well.
Your Honor, as the court is aware, the defendant, or the court may not be aware, but the defendant does not have a prior record. However, the state's recommendation in this case is not only based on the evidence in this case, but also based upon the fact that the defendant has not accepted responsibility for her actions and in the situation that she caused at the jail, and the fact that her actions potentially put inmates and other people at risk. For that reason, Your Honor, The state recommends the following sentence. With regards to counts 1 and 2, we believe count 2 would merge with count 1. The state's recommendations on counts 1 and 2 are 15 years to serve 10. State's recommendation on count 3 is 5 years to serve, concurrent with counts 1 and 2. Regarding counts 4 and 5, again, the possession in count 5 would merge with count 4. State's recommendation is 15 to serve 10. The recommendation for count 6, 5 years to serve, to run concurrent with counts 4 and 5. Count 7 and 8, Your Honor, the state would recommend 15 to serve 10, with count 8 merging into count 7. And on count 9, 5 years to serve to run concurrent. And then for the violation of oath, the state would recommend 5 years to serve to run concurrent.
So the state's asking for 3 of the charges to have a 15-year sentence with 10 to serve, and the other 2 charges to have a 5-year sentence to serve concurrently with the first 3 charges. So 10 years to serve with 5 years on probation, which, don't get me wrong, that's a really long sentence, but what she actually gets is so much worse.
In terms of evidence and aggravation, Ms. Boykin, at a prior hearing, you didn't have the case at the time, but it was Mr. Herzog who made representations that this case involved gang affiliation, that there were, and I know that there was a warrant taken out initially in this case about gang affiliation, and that he referenced other evidence showing that she was distributing directly to inmates. And so is that something the state is prepared to introduce in aggravation here today?
Your Honor, the state does have information related to that. We do not have the witness here to testify regarding those matters. Should the court hold a scheduling hearing or a hearing at a later date, we can have that witness available given this time of day.
All right. Well, not hearing a request to continue sentencing and the evidence not.
Would request for the court to continue sentencing to hear from that witness.
And the state's recommendation, though, would remain the same after presenting this aggravating evidence.
It would, Your Honor.
All right. And just by, wouldn't consider it unless we did hear that evidence, but by way of proffer to complete the record, what would be your proffer, what that witness would testify to?
Your Honor, the witness, Raylene Bruce, would testify that she too worked at the Fulton County Sheriff's Department. She assisted Investigator Green with obtaining the defendant's cell phone. A subsequent dump of that cell phone did show that the defendant was communicating not only with inmates, but with other individuals to sell items, to sell drugs within the jail. There are also some Instagram postings for the defendant. And there's also photos of her gang tattoos that were taken at the Fulton County Jail.
So not only was she bringing drugs into the jail for personal use, she was also a gang member who was distributing drugs directly to inmates. I swear, the more we listen to this case, the wilder it gets, and we're not even done yet.
All right, Ms. Young, at this point, should you choose to do so, this is an opportunity for you to tell me anything about yourself, your character, your background, anything that you think I should consider in mitigation, meaning why you deserve a lesser sentence and whatever sentence you recommend. And so to that end, the floor is yours.
So as I said earlier, on the record, we are in equity jurisdiction, correct? You have no answer?
I'll have an answer for you shortly, Ms. Young.
Okay. So, the failure or refusal to proceed in equity under exclusive jurisdiction will constitute in contempt of justice. As I said earlier, I was seeking administrative remedy, awaiting your communications to be delivered to correct parties. You are in contempt of justice by not allowing the surety, the implied surety, to produce this receipt of payment. So with that being said, my fee schedule will be on the record publicly soon, as soon as I can. But again, I have a 4-year-old son. Like I said, there was a lot of miscommunication. You have been in contact with my mother and my father without my knowledge, and they have miscommunicated the time that I was supposed to be back. I told them the situation. And as I was getting lunch and headed back to the courthouse where your officers intercepted, that's all that was being said. So and I was not read my Miranda rights as well, just putting that on the record as well. And also to clarify again, the respondent had a duty to all complaints and questions because of the legal special relationship of the parties by not responding to the respondent via the indictment, the true bill that was originally sent to the respondent. Is in breach of trust because of the infant estate and duty of care associated therewith and thereto in an express trust. The court and its officials, the prosecutor or the plaintiff, being that the state cannot represent itself, obviously, our legal title holder of not only the express trust, but also the constructive trust, as now have been placed on the record. I share the same or similar name again as the named defendant in their case number 23 SC 192047. However, for clarification, I am not acting in the capacity as the named defendant. I am the beneficiary and equitable title holder. None of this information is foreign to the court. This matter must proceed in equity, and failure or refusal to proceed in equity under exclusive jurisdiction, which you said we are in, will constitute contempt of justice. I am appearing, especially and not generally. I'm trying to let you know that this case has been settled. And until that notice reaches you, until I'm able to go do what I need to do to make sure your notice reaches you, I'm here. So again, I would like to seek administrative remedy, awaiting your communications to be delivered to the correct parties.
You're not going to have to wait long. He's about to deliver his remedies right now.
Ms. Young, you raised and said that you have a 4-year-old.
I do.
Who is caring for your 4-year-old at this moment?
I have no idea right now because his daycare closed at 6:00 p.m.
And so you've left your 4-year-old in the care of a daycare and made no plans.
My mother, I have no way to contact. I have no way to do anything because you intercepted before I could do what I was supposed to do.
All right. And so your mother has the ability to care for your 4-year-old?
I have no idea because I've not been able to speak with anyone. You are holding me against my will right now. So no, I have not spoken to anyone.
And what daycare is your son at?
Why?
Well, the answer would be because we want to make sure he's taken care of, and we actually have some regard for him, unlike what you've shown here today.
How have I shown no regard for my son?
Do you have anything further to present, Ms. Young?
Other than you're in contempt of justice? No.
All right.
You can proceed to doing
Okay,
whatever
with
you
that,
do.
I will announce the sentence in this case. I'll say I don't believe deferring or continuing this to a later date is needed because I'm willing, at a minimum, to accept the state's recommendation based on what's already been presented. I don't think aggravating evidence is needed here. I'll just start off by saying I don't think I've ever seen a more ineffective presentation at a sentencing hearing. Ms. Young, you've taken no responsibility not only for these acts, but you've completely thumbed your nose at this process and at the law that you swore to uphold. You've lied to me. You've embarrassed yourself and the department you used to work for.
Aw.
And you've contributed to the crisis we've had at this jail that we've had to experience for years. You're the cause of the danger that everyone who works there
The
and has
defendant
to be
is the
detained
cause.
there has to experience. So I'm not going to belabor the point, but the sentence in this
please, let's
case
get on
will
with this,
be
please.
40 years to serve 15 years with the balance on probation. We'll
sorry, you
stack
said
the
a balance?
charges, and Ms. Young can be removed from the courtroom because she's continuing to disrupt
Thank you,
the
bye.
proceedings.
Bye, have a great time.
Talk about how to ruin your life in less than 60 seconds. And I don't know if you caught it or not, and the judge will go over it in detail, but he said that she was to serve 15 years on a 40-year sentence. Here's the details.
All right. At this time, for the record, Ms. Young has again been removed from the courtroom because she continues to disrupt these proceedings. We have, she's back in the detention area, and we have had a deputy go back with her. The deputy is holding a laptop, which is live streaming these proceedings in real time so that she can still hear the conclusion of the court sentence and the advisement of her rights, which is very important. To conclude, I think the heart of this case is the violation of oath by a public officer. So I'm going to have that as the lead count. So count 11 would be 5 years to serve. I'm also going to make a special note on this sentence that this sentence is not going to begin running until 40 days from today's date, and that it's going to be consecutive to the court's order of contempt, which has already been filed and was entered on today, January 28th. So count 11 would be 5 years to serve. From there, we return back to the top of the indictment, where the sentence would be 30 years to serve 15 years with the balance on probation. Strike that. That would be 30 years to serve 10 years with the balance on probation, which is to run consecutive to count 11. Count 2 merges into count 1. Count 3, crossing guidelines, would be 5 years to serve consecutive to count 11. And concurrent with count 1. Count 4, possession of a Schedule II controlled substance with intent to distribute. That's going to be 30 to serve 15. Again, that's consecutive to count 11. That's concurrent to count 1. Count 5 merges into count 4. Count 6 is the crossing guard lines. That's 5 years to serve. That's consecutive to count 11 to run concurrent with 2 and 4. Count 7 is the possession of a Schedule IV with the intent to distribute. I think at this point, since I had announced a 40 serve 15, there still needs to be another 15 years on probation. And so count 7 would be 15 years probation consecutive to count 11 and consecutive to count 1 and 4. Count 8 merges to count 7, and count 9 is 5 years to serve consecutive to count 11, concurrent to count 1. I will double check the math on this, but again, the sentence is 40 years probation to serve 15 years with the first 5 on the violation, the next 10 to serve on the possession with intents, and then probation to follow from there.
This is one of the best examples of fuck around and find out that you'll ever see, because she just found out that the prosecution's recommendation of 10 years to serve in jail with 5 years on probation was just a recommendation, because the judge ended up giving her 15 years to serve in prison with an additional 40 years on probation for all that fucking around that she's been doing. And he had this little bit to add at the end.
I'll just state for the record that I had been observing Miss Young throughout this trial, and I think I've seen a method to her madness, especially when cross-examining the witnesses. She knows what the issues were in this trial, and just has a very grave misunderstanding of the law and how she thought she could be successful in this case. So I didn't have any concerns about her competency to proceed in this case or her criminal responsibility here.
In other words, she knew what the fuck she was doing, and she knew that it was wrong. Alright, so that's the end of the video. I'm glad I was able to catch this one for you guys. And don't forget to head over to Colin's channel so you can catch me and Colin talking about the parts that I didn't cover on Monday. And if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.